May I proceed?
May it please the Court. Good morning, Your Honors. I'm Peter Onick for Jonathan Vick. Your Honors, I'll start with the issue as to which Mr. Vick sought direct appellate review. There were duplicative convictions in this case, and they were duplicative under the principle that you have repeatedly announced, namely that there are circumstances where two charged offenses are so closely related, in fact, as to be but one criminal offense. The two...
Well, on that issue, isn't it essentially a question of whether we're going to stick with the Morey test of the elements-based test or stick with the other test, first announced, I think, in St. Pierre by Justice Kaplan, that whether the actions are essentially emanate from the same facts, a related set of facts?
Well, those are parallel tests, Your Honor. The traditional test, the standard test, is the Morey-Blockberger test, which compares elements.
Right.
However, this Court has repeatedly enunciated, including at least 3 times in this decade, in Valliere, and then in Keohane, and in the Jones case, that there is a parallel test where, in certain circumstances, even though the elements test of Morey and Blockberger is not technically met, nonetheless, the two charged offenses are so closely related that in essence, it's one offense. And that's what happened in this...
I'm not saying I disagree with that. I wrote Keohane and I struggled with that whole concept. I did a lot. But does the, if you want to call it the Jones test, I call it the St. Pierre test, but it doesn't matter. Does that test actually swallow up, though, the Morey elements-based test?
Well, that's one of the arguments the Commonwealth makes. It is a just test.
Yeah, I think it may well be a just test,
whether or not,
but then you can't apply the elements-based test anymore.
Well, doesn't it really depend on? It's a you would say a very small subset of Morey.
Very small, Your Honor.
Where it's one act and
yes.
You have two offenses, but
that's
it's one
precisely
act.
right, and that's exactly what happened in this case, Your Honor. Literally a second or two.
But that
the
would
hand
be
is
all
raised, the shot goes off. That's it. 2 crimes.
Yeah, but then what do you do with that? The cases, there were a few cited that upheld both receiving stolen property and B&E.
Your Honor, I'm not here. I'm here to represent my client.
I know, but that's one of those cases was cited in the briefs of the Commonwealth, in the brief of the Commonwealth.
You're speaking of cases where
though they were upheld.
And received.
Those two. There was the fellow out in the western part of the state who was part of a ring, and he was he was charged in one set of offenses in the district court and the other in the superior court, and we upheld that. Receiving and B&E.
Receiving and B&E. I'm not.
Okay.
I'm not particularly familiar with that very case, Your Honor. There is a small subset of cases, and this issue would only arise in a small number of cases where the two charged offenses are temporally close. That's one of the tests. Here, it's a 1 second or 2 second event total.
I disagree with you. I think it would arise in a lot of offenses because we see it come up quite frequently. I mean, just look at the cases you cited. Come up in all those cases.
Well,
and if it gets up here, imagine how many there are that don't get up here. So I think that.
But the question is not this Court's jurisprudence at this point that there exists, in addition to the standard Morey-Blockberger test, which is sort of the default, the mainstream test, is there not also a parallel test, which this Court has, in fact, announced several times, dating back at least to St. Pierre and through the 1981 Jones case, which I cite as really the seminal case, because all the Valliere, Keohane, and 2004 Jones all cite 1981 Jones. That's the motor vehicle homicide, which was duplicative with the manslaughter. It was the very same act, driving on the wrong way on the road. Here it's the very same act. The assailant raises the gun, shoots. The crime is over in 1 second, and yet 2 crimes emanate, the ABDW serious injury plus armed assault with intent to murder. That is unjust and duplicative, and properly so.
But isn't the issue legislative intent? I mean, we
Yes,
do
Your Honor.
permit for the same act when the legislature, when there are no new elements except for one, as in school zone cases, but the legislature expressly declares that there may be consecutive punishment, in fact requires consecutive punishments, we say okay. The Blockberger test essentially says there's a presumption that the legislature did not intend there to be separate sentences unless there is a different element. And can't our exceptions to that rule be viewed simply as us viewing the legislative intent as not wishing there to be separate sentences because there is nothing new about those offenses? Isn't that the analysis?
Well, Your Honor, the analysis, I believe, should be whether there is some reasonable basis for the legislature to think that there are that different policies might underlie the two offenses.
But I mean, if that's the case, don't you have a problem because you have one crime says an intent to murder, that's bad, and another crime says serious bodily injury, that's bad.
Well, that sounds a little bit like just saying that those are the elements. But what is the policy? The policy, for instance, burning a car. There's a case involving burning a car. So there's injury to the property, but there are also insurance implications. So two different crimes can emanate from the burning of the car because there's the owner's property that's harmed, and then there's the insurance implications. So two legislative policies. What are the two legislative policies that could possibly be thought to underlie these two crimes, ABDW and assault with intent to murder? Citizens shouldn't be going out shooting other citizens and harming them. That's the policy. Yes, there are some small differences in the elements which take this out of the Maury-Blockberger ambit, but the fact is that's the policy. It's a two-second action, temporal. Form of conduct is another one of the factors. Well, it's exactly the same conduct here. It's not just form of conduct. It is the very same conduct. And legislative policy, is there conceivably any separate policy reason underlying each of those two offenses that could justify two convictions? The answer is no, unlike in the insurance, the car burning, property harm insurance and that sort of thing.
Do you concede that if we adopt a strict elements-based test here, that then your argument loses?
Yes, and that would be unjust, Your Honor.
Yeah.
I think the reason that St. Pierre in 1981, Jones, and all your other cases, Keohane and Valliere, the reason why this court adopted and repeatedly applied that parallel course is because there are cases where just palpably a just outcome requires a little bit broader thinking than the trammeled thinking of the Maury-Blockberger test. That's a very literalist, technical kind of test. It has its place. It is important. But the broader aims of justice require this separate path which you have carved out. Now, my concern in seeking direct appellate review is that the appeals court, at least some judges on the appeals, seem not to accept this.
Well, it's kind of hard to articulate. Can you articulate for us? What is it that we should be articulating, besides that there's a separate test?
If both the offenses arise from the same course of conduct, I think it's rather simple.
Whether the three tests, temporal, similar form of conduct, no separate legislative policy reasons. Those are the three that one reads in the cases. This Mr. Vick's case meets all three of those tests.
But you could, just to pick up on, I do want to turn to the consciousness of guilt, but let me just ask this. There are policy things, because just to take from what Justice Gantz said, if you have an armed assault with intent to murder doesn't actually have to have injured the person at all. And you could have the same problem, but then you've got ABDW causing injury, serious bodily injury. So they are looking at two different things.
They are literally two different things, of course, Your Honor. They are literally two different things. And the elements are literally different enough that they don't fit
No, but
the
it's not just abstract. I mean, you can see the reason why the one definitely doesn't cover the other.
But isn't the overarching policy reason that people shouldn't be going out injuring or trying to injure other people? It's a sort of a very basic notion of...
Right, but under your theory, it's irrelevant that he didn't miss. Because if he had shot and missed, it may be assault with intent to murder, but the law generally recognizes that there's consequence to him hitting the person, and that's what the bodily injury reflects.
Well, and that's the difference in the elements. There's no question that these are the crimes as set out in their elements are different. But the jurisprudence that this court has set forth, and I think it is the proper jurisprudence, is that in a limited set of cases, the technical, literal, trammeled interpretation should give way to a slightly more generous interpretation to respect the reality of what actually happened. Here there was a single shot. 2 seconds, 1 second. The arm raised, the shot went off. That is it.
On the consciousness of guilt issue, is there any evidence that your client was running away from the scene?
No, Your Honor. He was
Some
just
people in the
walking.
brief says run.
And that is
Says
very
flee.
important. In
Someone
fact,
says
fleeing from the
flee,
scene.
yeah.
The judge instructed about fleeing
Fleeing.
from the scene, but was there any evidence of that?
no, Your Honor, he was walking in the park. In fact, defense counsel wanted to pin this point down. Was he running? No, he was just walking. The quote is in the brief. He was just walking
Was he
away from the general area where the event had happened.
Was he with, there's a suggestion in the Commonwealth's brief that he was, at least this is how I read it, standing next to, and I'm not going to remember, was it his cousin maybe? Somebody was arrested there, and then he was walking away, and I couldn't tell whether they were, as close as Justice Cowan and I, or was there any evidence about that?
We're not going to know exactly how close. Somebody else, what happens is after the event, police swarm into the area, and many young men are apprehended or chased. The cousin, William Deans, is jogging slowly away from the area and is chased down. Mr. Vick is next to someone else. I'm not sure it's clear who that someone else is, and walks away from the
And is
apprehension.
that someone else arrested?
I don't even know if that someone else probably was arrested. I'm not sure who it is or whatever happened to that person. But there are a lot of apprehensions going on, and people are moving about. This is a busy park. It's July. It's a sunny day. The pool is packed. There are many people in the park. This is a crowded public space with many people out walking, swimming, doing things, having recreation.
Maybe I misunderstood the Commonwealth's brief. I thought they were implying that he walked away from his cousin's arrest.
No, his
You're
cousin
saying-
is William Dean, and William Dean is one of those who was apprehended jogging slowly, so slowly that the police officer who testified to apprehending him didn't have to break into a run himself. All of this was parsed out carefully at the trial, how quickly were people moving and so forth. But even if William Dean is jogging slowly away, my client is walking. He was just walking. Now, what is the consciousness of guilt in that? He's just walking in the
I guess
park.
the theory is he wasn't at the scene, so he must have fled.
Exactly.
So therefore, he must have been at the scene.
Exactly, Your Honor. Now,
Racist.
that captures the circularity, of course, that defense counsel pointed out. It presupposes that he was at the scene. Well, that's the issue for resolution at the trial.
Well, I may agree with you that there's no evidence of consciousness of guilt here, but I couldn't follow this argument about presupposing that he was at the scene. Consciousness of guilt always presupposes that the person is guilty. Otherwise, it presupposes that he was there and did whatever it was.
The reason
So I
it's
don't
bad
follow
to
that
presuppose
part.
that he's at the scene is that this is an ID case, Your Honor.
Yeah, but
This is an ID case.
that could be, suppose it's a rape case and it's an ID case, but he fled to North Carolina. Commonwealth was always permitted to put in evidence of consciousness of guilt by fleeing, even though it's an ID case in a strange
Well, that
way.
may be so if on its face.
So I don't understand. That's why I don't understand your argument about presupposing. You have to have the presupposition that he was at the scene in order to get consciousness of guilt.
But that's the
instruction.
circularity that's not
But
permissible
that
under
applies
Grosset.
in all consciousness of guilt cases.
But aren't you saying that it presupposes he participated in the crime as opposed to it assumes that he was at the park? Isn't that the distinction?
Say it again, Your Honor, I'm sorry.
Presupposes he participated in the crime
Yes.
as opposed to presupposes he was in the park.
Oh, yes, absolutely.
Yeah,
I think that's
the
what defense counsel meant. If you say that his walking away a few minutes later is consciousness of guilt, it presupposes that he was at the scene of the crime itself, that he was there at the shooting.
And the other.
He is palpably in the park. He is walking in the park like many other people were that nice sunny day in Everett. The many people were walking in the park, and he was walking in the park.
The shirt, he did say, with respect to the shirt, he did say, that's my shirt, I had it on all day, right?
Yes. Now, they try to make consciousness of guilt out of that, at some point in the holding cell, he gives that shirt to his cousin, William. He tells the officer that he did that because William had said he was cold. And and the judge said, well, couldn't that be seen as an effort to confuse people as to who was wearing what shirt? But my client also told the officer, yeah, but I was wearing it all day. He admits that he's been wearing that shirt all day. This is not consciousness of guilt. This is the obverse of consciousness of guilt. Yeah, that's my shirt.
Except he admits it after he understands that he's been filmed.
Well, that's a very attenuated inference, Your Honor. The fact is, he says to the officers, yeah, that's my shirt. I was wearing it all day, but I just gave it to my cousin because he said he was cold here in the holding cell, which is totally plausible. And the other statement, I was here to hang out with my cousin and some other buddies and to go swimming. Well, there's a swimming pool. It was packed that day. He was near the swimming pool. He's in the park.
Thank you, Mr. Onek.
Thank you very much, Your Honor.
Good morning.
Ms. Jefferson-Casper, good morning.
May it please the Court, my name is Denise Casper. I'm an assistant district attorney with Middlesex. With me is Elizabeth Keeley, who was the trial ADA in this matter. The defendant's convictions for armed assault with intent to murder and assault and battery by means of a dangerous weapon resulting in serious bodily injury were not duplicative. The defendant was charged and convicted of these two serious crimes for the single act of having shot the victim at close range in the chest after a pushing and shoving contest. As this Court has made clear in its decision all the way back in Commonwealth versus Morey, a single act, like the defendant's here in this case, can properly lead to more than one charge or conviction where such act violates two different statutory schemes that require different showings of proof. And that was the case here. For the armed assault charge, there had to be a showing that the defendant assaulted the victim, that he did so armed with a dangerous weapon, and that he did so with a specific intent of causing the victim's death.
Ms. Casper, I don't think anybody disputes it meets the Morley test. What do we do with St. Pierre and Jones and Cohane? I mean, that's really the issue here, isn't it?
Yes,
I mean,
Your Honor.
there's no dispute that they are separate elements. I mean, Mr. Onek readily conceded that.
Yes, Your Honor. In light of that concession, in regards to the so closely related language, that language did appear for the first time in Justice Kaplan's decision in St. Pierre, but nothing in that case suggested that Morey should be amended to include the inquiry into the conduct-based test that has now been cited in a number of this Court's opinions. In the St. Pierre case, the Court was faced with a very particular concern. They were concerned that the prosecutor had parsed the mayhem statute so narrowly that it had avoided making the other charge, the assault and battery dangerous charge, a lesser included of the mayhem charge. In that case, in fact, the convictions were allowed to stand. It's the subsequent cases that have picked up that so closely related language as another test in addition to the Morey test. And for a number of reasons, this Court should not modify Morey in that regard.
Viewed one way, we have modified it. So I mean, essentially, the defendant's argument here is we've modified it. That's the jurisprudence because for reasons of justice, essentially. So the question is, why should we, in essence, reverse that jurisprudence?
Your Honor, for a number of reasons. One, which
was the Morley test a common law test?
It's a common law test, Your Honor. And if we add the so closely related test, the conduct-based test, it would turn Morey on its head. As in Morey, there was a single act that led to lewd and lascivious and adultery charges. The same is true here, especially when, as Justice Gantz has pointed out, I believe, these two charges were addressed to very different harms. The armed assault charge was focused on the defendant's intention to do harm and the legislative interest in deterring that type of intention, whereas the A and B charge was focused on the harm to the victim. It starts from the premise that it's a single act.
Excuse me, I understand that there may be two different purposes. One is you may miss. The second is that you may, in fact, injure somebody in a way where it would be difficult to establish intent to murder.
Yes,
Can
Your
you
Honor.
think of any set of circumstances where somebody takes a gun, points it, shoots, injures, where you wouldn't have both intent to murder and serious bodily injury?
Yes, Your Honor. If it was in a case where the defendant is waving the gun around, in this scenario where there's several people involved, and he's gesturing to have the crowd move back and then shoots, there may be an instance there where we couldn't make the showing of specific intent to cause death. And I think, Your Honor, that points out the fact that it's appropriate to have two charges arising from a single act. Your Honor, I would also suggest adopting the so closely related language here and amending Morey formally in that regard would also be inconsistent with the federal Blackburger test. And in fact, the United States Supreme Court has been faced with the same issue that this court is now faced with about whether it should adopt any part of that test that's content-based. There's discussion of this in the dissent by Justice Cipher in the recent Niles N case. After Blackburger, in the Grady case, the court in 1990 adopted a content-based test for successive prosecutions, but later, 3 short years later, it abandoned that test and reaffirmed that the elements-based test, the Blackburger test, was the test that applied. And, Your Honor, there's another more practical reason why Morey should be confined to the elements-based test and not the content-based test, and that is it is more difficult for appellate courts to apply. It's inviting the court to parse the facts in the conduct-based test in a way that it doesn't need to in regards to the element-based test. And I would say that Morey appropriately is a rule of statutory construction and discerning what the legislative intent is.
Assuming we're not going to take our language back, that there are offenses that may be so closely related that it would be unjust to impose two punishments. How does this case, why shouldn't this case be one of those?
Your Honor, I would say because it leads to a just result. Obviously,
You mean having two punishments leads to a just result?
I do, Your Honor. In this case, one, because the two charges are addressing different harms, but also because I think there is an interest in having separate punishments here. And I want to put this in the context of post-truth in sentencing, where in superior court you cannot, on a single charge, have both a state prison term of incarceration and a term of probation. Here, obviously, the trial court thought it was an appropriate sentence to both have a period of incarceration and probation. If you were to take away the second charge, then that would not be a sentence that was possible, where clearly, given the defendant's conduct, there's certainly a public
Were
interest.
there no other convictions here, just those two?
Well, there was, and in my hypothetical, I was taking out the firearms and ammunition charges. But I think before the court had inquired of my brother of why we think these cases with two charges arising out of the same act keep coming up, and I think it's because of, one of the reasons is because of the truth in sentencing, and trial courts have relied on the Morey test and the predictability of the Morey test in fashioning sentences, and certainly the Commonwealth has in thinking about what charges to pursue. Your Honor, there are other reasons why the Morey test should not be modified to include this so closely related language in every case.
I don't think there's a suggestion here that it should be modified in every case.
Well, certainly not in this case, and
Now,
if I can
Blockberger
address
was
that.
concerned with double jeopardy, right?
I'm sorry.
Blockberger was concerned with double jeopardy.
Yes.
And is there a double jeopardy issue here?
Well, there isn't, because our position is that the charges aren't duplicative, and so having punishments on each charge, there's no double jeopardy. That was addressed involving these two exact charges by the appeals court in the Aragata case. And, Your Honor,
double jeopardy means not only being tried twice, but it means being essentially sentenced twice.
Yes, Your Honor. And here we would say, because the charges are not duplicative, there also is not a double jeopardy violation.
Do you want to turn to the consciousness of
Yes, yes, Your Honor. First, in regards to the consciousness of guilt, the court properly instructed the jury on consciousness of guilt in this case. The jury instruction itself comported in all respects with the Tony standard.
Why is just walking away from the scene a consciousness of guilt?
Well, Your Honor, I think, respectfully, I think the record suggested more than that, Your Honor. There was testimony from the two eyewitnesses, and just looking back at the transcript, in Mr. Lloyd's testimony, he was one of the two construction workers in the truck. There was testimony at day 2, page 56, and could you hear the gunshot? Answer, yes. And what happened when the person wearing the trick shirt fired the gun? Took off through Glendale Park. Okay, what happened to the person shot? And then he goes on to testify that the victim also fled. Your Honor, in this case...
So you're saying took off equals ran?
Yes, Your Honor. It was not simply the testimony at trial that the defendant tried to distance himself when his companions were being detained by the police, but that earlier that the
How does that help us establish that it was the defendant at the scene? The fact that whoever was at the scene and everyone else apparently ran away.
Because, Your Honor, this isn't a circumstance like the Gross case that defense counsel has relied on, where it's a single ID witness case. Here, there are a string of circumstances that the defendant is found in the vicinity of the shooting, shortly after the shooting. He's wearing the same distinctive shirt that the witnesses
All of
said
these,
the
this is
shooter-
all relevant, of course.
that the shooter had been wearing, that when his companions are being detained by the police, he doesn't protest at all. He tries to distance himself
Excuse me,
from
he
that.
doesn't protest?
Yeah,
Meaning that he doesn't do anything to assist them or to protest their
Why would one do
detention.
that?
Well, Your Honor, I think there's an argument if you're there for an innocent reason, you might.
well, but if you look, I mean, I'm sorry, I may be misreading this, and I haven't read the transcript, but as I understand the testimony, the two eyewitnesses see 3 African Americans and 5, I don't know whether they were Hispanics, I don't know, but
I believe the record was they were all African American.
police come on the scene, they go into the park, they immediately subdue 5 black males. They see 3 in a group. One is a backpack. He takes off. They chase him. They find a gun. They arrest the other 2 as well. Defendant's not him, not one of those 3.
Yes.
They then proceed to arrest more black males. And the defendant happens to be one of them.
Yes, Your Honor. And then shortly after that, there are show-up identifications by the 2 eyewitnesses.
I know,
in the
but
truck.
in that context, why you say, well, the defendant didn't protest the arrest of others, therefore, that's evidence
Well, he
consciousness
didn't
of guilt?
protest, and I should be more specific than that. He didn't protest the person that he was walking with as the police detained him and attempted to distance himself. But, Your Honor, it's the all of those, the totality of circumstances that show that you don't have to presuppose the defendant's guilt to show that the defendant fled the scene and that that was appropriate consciousness of guilt.
Well,
And
I would agree with you. If, in fact, the police were approaching these individuals who they reasonably suspected were involved, and the defendant takes off down the alley and round the corner and they chase him down, maybe that is evidence of flight, and that's helpful to identify him as being someone who had been at the prior scene. But that's not this case, is it?
No, Your Honor, he doesn't flee at that moment. He does try to distance himself. But, Your Honor, looking back at the testimony of the 2 eyewitnesses, we certainly have evidence that he was among the people that fled the scene. And in combination with all of these other facts that I cited, it doesn't have to, you don't have to presuppose the defendant's guilt in the way that the court said in Gross, or the appeals court rather said in Gross.
I mean, the only thing that's on, all of this makes sense except this consciousness of guilt instruction, which sort of gives some heightened value to the fact that he wasn't at the scene.
Your Honor, but I do think that given that the instruction itself was proper and it left it to the jury to decide what that evidence was, what weight,
we
if
have
anything,
to decide
do it.
first whether the instruction was proper.
Yes, Your Honor, and I would say for all of those facts that it is. This is closer to the appeals court decision in Horseman, in which there were a combination of combination of testimony and evidence from various witnesses about the assailant. And the court there said it was the web of those circumstances that made the instruction proper, even though the defense was misidentification, as it was in this case.
Does it all hinge on that witness's Lloyd's testimony that he took off? You don't cite anything in your brief, and I don't see that you even cited Lloyd's testimony. But does it all hinge on that? Whether he ran?
Well, I know that there have been cases where if there wasn't evidence of flight, the consciousness of guilt instruction wasn't necessarily improper. Here, I do think it hinges on what the testimony was of the flight.
Is there anything else besides Lloyd's statement he took off?
I believe, and I was not able to find right now in Mr. Reed's testimony, I believe their testimony was similar in that regard.
But wasn't it the testimony actually the shooter wore a shirt that said trick?
Yes, Your Honor,
And
tricks.
the person in the trick shirt then left?
Yes, Your Honor.
And the defendant had on a trick shirt?
Yes, and also, and in combination with the other facts that I mentioned in regards to the defendant being found in the vicinity of the shooting shortly after the shooting.
Let me ask you this hypothetical. Let's assume the police went to the park and there were two people wearing trick shirts. They arrest both of them. Or they arrest one of them, but there are two people wearing trick shirts, three people wearing trick shirts.
Well, Your Honor,
Is there still consciousness of, would there still be a consciousness of guilt instruction?
there potentially could, Your Honor. I mean, I guess what the only reason I'm pausing is the defendants, I don't believe, were arrested until after the show-up identification. So there's a little bit more, at least in this record, suggesting.
But they identified him principally by the shirt.
Principally by the shirt, Your Honor.
Let's say I'm just trying to figure out if there were a couple of people with shirts, and whether or not the fact that they were not at the scene establishes that because they had the shirt on,
Well,
there was a consciousness of guilt instruction would be appropriate.
Well, Your Honor, I think you would need more facts, as we have in this case, that points specifically to one individual. And I would say it's the combination of all the circumstances that I've mentioned here, in addition to his having worn the trick shirt, that distinctive shirt.
But on that hypothetical, each and every one of the people that wore trick shirts, if they had been charged, the evidence would be the same, that there was flight from the scene. Whoever was at the scene wearing the trick shirt fled, and that's consciousness of guilt. And that is which helps establish that they were the person at the scene. That's your argument?
Yes.
So that evidence would be the same as to anybody who had a trick shirt on was in the park.
Yes, although I would say that the facts in regards to this defendant are more distinctive as to an individual defendant.
Thank you.
Are you saying that, I mean, is the Commonwealth entitled to a consciousness of guilt instruction every time a defendant is apprehended someplace other than the scene of the crime?
No, Your Honor.
So,
no, because I mean,
what happened here that takes it out of that category?
Because I think it's the difference between the Gross case and the Horseman case. I mean, the Gross case, there's a single ID. The defendant flees. Nobody else sees him in the vicinity. He claims that his alibi was that he was somewhere else, not in the vicinity of the crime. The Horseman case, which we argue is closer to our case here, there are a set of circumstances where numerous witnesses observe him at the scene of the crime, make later identifications, and he's found in the vicinity of the crime around the time of the crime. That's where, Your Honor, I think the difference is. So you wouldn't get it in every case in which the defendant is not found at the exact scene of the shooting, but you would get it in the circumstances here where there are a number of
Was the
factors
defendant
and
found with a gun on
facts.
him?
Your Honor?
Did the defendant have a weapon on him when?
He didn't. The weapon was found in the backpack with the
Was
T-shirt of
that,
one
because
of the
that
other
wasn't clear from the
defendants.
briefs, was that actually the weapon that was used?
Yes, Your Honor.
So he wasn't actually even found with the people who had the person who had the weapon.
No, the testimony at trial was that his companion, Mr. Smith, was being chased by the police and threw off the knapsack, which contained
I take
a
it that,
firearm.
at least from the brief, there were 3 black males that were standing together. One was wearing a backpack. The police approached. The one with the backpack took off.
Yes.
The defendant was not one of those 3 males.
He was not one of those
Right,
three.
and the gun was in the backpack.
Yes, Your Honor.
So the companion is, that's not, when you say companion, there isn't any real evidence at the time the police were there that they were companions, is there? He
No,
wasn't one
Your
of
Honor,
those
there
three.
were other companions. There were a total of 5 individuals with the defendant at the time of the shooting. And when the defendant...
I'm sorry, was there evidence of that? I thought the
That's
eyewitnesses
assuming
saw
that it
3.
was the defendant.
I mean at the time of the shooting, Your Honor. At the time of his being detained, he was with... there were 2 other individuals, and it was not the individual who was carrying the knapsack at the time that the defendant was stopped and arrested.
Thank you, Ms. Casper.
Thank you, Your Honor.